The Constitutional Court, as you've heard, has found the Public Protector Busiswe Mkhwebane had no evidence that President Cyril Ramaphosa benefited personally from the donations made to the CR17 campaign. Judge Chris Jafta handing down the judgment this morning. We're joined now by the political analyst, Professor Tefo, and the legal analyst, Benedict Phiri. Gentlemen, good evening. If I can start with you, Benedict Phiri. The Constitutional Court today being quite critical of the Public Protector's conduct here, saying she misinterpreted the law, she did not conduct herself properly. Is that criticism merited?
I think it is, Stephen. When you go through the judgment and you look carefully at the facts that Judge Jafta went through, I think it's very clear that, the complaints that were laid by Musi Maimane as well as the EFF had nothing to do with the CR17 campaign. We turned something that was 500,000 into CR17 campaign donations. Over and above that, the Public Protector effectively inserted wording into the Executive Ethics Code around deliberately misleading Parliament, and saying that could also mean inadvertently misleading, which wasn't there. So that's absolutely something that's not provided for by law. And I think the most scathing criticism from my perspective at least is, I heard Judge Jafta saying in some instances there wasn't even a shred of evidence to justify the findings and the conclusions that she came to. So I think if you look at the conspectus of those three sort of elements, at least, I think the criticism against the Public Protector is justified.
I mean, there's one point where they say that she has a duty to come to these investigations with an open mind, and I think the phrase they used was she was, unduly suspicious of the person she was investigating. I mean, there's a sort of, perhaps an attribution of motive there in a way.
Yeah, it is an attribution of motive, and I think a fair one, because, she says things like there's a suspicion of money laundering because the funds went through a chain of entities, which is absolutely wholly untrue. When you look at the facts, it was one entity. She didn't look to, for instance, to the corroborating evidence from the people that had deposed affidavits to her, that had put evidence on oath. Instead, she went with her suspicion. So I think there is a reasonable imputation of motive given what she ignored for most instances.
There's a big part of this is that she received photocopies of emails, in a way, literally sort of under the door, and she refused to allow President Cyril Ramaphosa to respond to this. And this is interesting, Benedict. If someone, put an email under my door saying that you were a supporter of Kaizer Chiefs, and actually you were a very sensible fellow and supported Mamelodi Sundowns instead, before I came to a finding, I'd have to ask you who you supported.
That's correct, Stephen. And I think that, the big issue around this was she couldn't say how those emails came into her hands. And obviously they had sensitive and private information of individuals and other parties that, you could not disclose in that manner. So I think there was really a question mark around that. And I think that's where really there is a boon for Amapungane in this judgment, because I think they are then able to ride on elements which are still sort of secret within this judgment and test this aspect around raising money within a private campaign for a political party, if you're an MP or a member of cabinet, etc., which is still a gap that the Political Funding Act doesn't deal with at the moment.
Benedict, there's another big issue here, and this Amapungane issue is very important. They obviously want transparency, and as I understand the argument, there is a law that says that party political funding must now be made public. It's also important for people to know who actually pays or contributes to internal campaigns, whether they be in the ANC or the DA or the EFF or whoever they are. This is quite an important principle. Do you expect a lot more legal stuff, a lot more litigation on this?
Yes, and Judge Jafta was very clear to say that the South Gauteng High Court didn't really apply their mind properly in dismissing Amapungane's application, because there is a constitutional point here around the right to public participation. The Political Party Funding Act doesn't quite extend to individual campaigns and political parties at the moment. So theoretically, there is a lacuna where we could miss on, who's giving money to political parties and, potential political contenders. And there's no doubt that, Mr. Ramaphosa received a lot of money for his campaign, and as a result of which he is president. And as the public, we're none the wiser around that. And I think Amapungani has really brought a good test case, which I expect to be ventilated through the courts over the years.
Benedict Phiri for that legal analysis. Thank you very much indeed, Professor.